Princess Diana is seriously injured and 2 other people have died following a car crash.
Already daybreak there in Britain. Many people getting up with a morning cup of coffee, discovering by tuning in to the BBC that Princess Diana has died as a result of a car crash.
On August 31st, 1997, Princess Diana of Wales was killed in a fatal car crash in Paris that sent shockwaves throughout the world. A French court placed liability solely on the driver, who died in the crash and whose blood alcohol level was found to be well in excess of the legal limit. But many asked, was there anyone else to blame? What about the French paparazzi on motorcycles chasing Diana? The hotel that allowed the driver to drink? The dangerous columns unprotected by guardrails? In a non-binding inquest costing £10 million and involving over 200 witnesses and 6 months of jurors' time, a UK court delivered a verdict that both the driver and the paparazzi who pursued her were grossly negligent, a finding that equated with manslaughter. What do these 2 verdicts illustrate about the differences between the Roman-inspired civil law system used by France and the Anglo-American common law system we are familiar with in the United States? Who do these systems blame for auto accidents, and who should they blame? In the English and American common law systems, judges develop legal interpretations that evolve into new standards of conduct. Most of tort law was created this way. In contrast, civil law systems develop legislative codes defining wrongful conduct. Both civil law and common law systems have historically held drivers liable for accidents they cause. Under the French Civil Code, for example, people are responsible for damage caused by things under their control, including cars. So, drivers are almost always held solely responsible for car accidents. In a landmark 1930s case, a child was seriously injured when a vehicle turned over. France's highest court held that since the driver is more likely to have control over the circumstances leading to an accident, the driver's presumption of responsibility can be rebutted only by proving force majeure. So, unless there's an extreme unforeseeable event, the driver is responsible. This reasoning may explain why French courts did not blame the paparazzi for Diana's death. Common law systems, such as the United States, also began with the presumption against the driver. However, the flexible role of judges in common law systems eventually allowed victims to recover from other parties contributing to the crash.
Up until the 1960s, the law was distorted because it assigned responsibility almost overwhelmingly to the driver in terms of collisions of motor vehicles. The auto industry had a deprecatory phrase that said all crashes are due to the nut behind the wheel. We had the 3 factors, driver, highway, and motor vehicle, in a human factors type interchange, and only the driver was held culpable.
An Ames woman holds on for dear life after her accelerator sticks on Interstate 35 in northern Missouri.
All of a sudden I just started picking up speed. I'm picking up speed, and I'm going like 80, almost 90 miles an hour headed to Bethany, and I'm scared to death.
These lawsuits extended liability to allow victims to recover from new parties. Beyond that, these lawsuits led to legal innovation that made society safer.
It's important to know that much of the information which we use to get federal motor vehicle and highway safety legislation came out of court lawsuits, came out of the common law of courts, depositions, interrogatories, subpoenas that spilled out of Ford and GM, Chrysler, VW.
Public disclosure of automobile safety practices through the discovery process pushed the boundaries of the common law. As a result, contributors to the driver's situation, such as manufacturers, were also liable. Courts no longer focused only on the so-called nut behind the wheel. But some countries have taken an even bolder stance on car accidents. Countries like New Zealand view accidents as a common but random occurrence in everyday life, since our modern industrial society creates the situations leading to these accidents. Society as a whole should bear the cost of injuries. Before reform, The car accident system in New Zealand was facing unpredictable damage awards and high lawsuit costs. To address these problems, it established a no-fault system. In a no-fault system, people contribute to a pool of money that compensates accident victims without regard to who caused the accident. The compensation for car accidents is considered extremely generous, including medical costs, 80% wage compensation, and other benefits. New Zealand enjoys cost savings from avoiding litigation. However, the downside is that people are not held liable or incentivized to change their behavior.
I favor a system of legal accountability that is empirically granular. So if that person driving a car hits another vehicle, you can say the person's behavior caused the crash, but it's the auto companies, without providing seatbelts, airbags, padded dash panels, collapsible steering columns, that led to the injury. So you would bifurcate the responsibility that way.
How do we decide the best system? We want to blame people for bad outcomes. Sometimes that is justified, and holding that party liable may incentivize safer conduct. But other times, we need to remember situational factors. We see the passion for blaming in the Princess Diana case. While people rush to blame the driver and the paparazzi, the tunnel's inherently dangerous columns, unprotected by guardrails, received minimal attention.
She was the people's princess, an iconic figure. But was Princess Diana murdered by the Secret Service on the orders of the British establishment?
Because she was such an extraordinary woman, people find it completely unacceptable that somebody like that should have such an ordinary death, a car crash.
The loss of a public figure is sad and frightening. When Princess Diana died, rich and poor alike searched for answers. Did Princess Diana deserve this level of attention? Perhaps it is not justice we really seek, but the perception of justice. In 1997, the year of Diana's death, over 3,000 British citizens died in auto accidents, and over 100 times more were injured. But there was no £10 million investigation. After Princess Diana's death, some jurisdictions began passing anti-paparazzi laws, but neither civil nor common law countries adopted reforms to account for situational factors in ordinary car accidents. In our quest for blame, perhaps we are missing opportunities to improve society.